The certified letter arrived on a Tuesday morning in March, and I almost threw it away thinking it was junk mail until I saw the Meadowbrook Estates Homeowners Association seal embossed on the envelope. Inside was a formal notice of violation and a $500 fine for what they called excessive and inappropriate holiday decorations displayed beyond the approved seasonal time frame. I stood in my kitchen in Phoenix, Arizona, staring at the paper like it was written in another language because I hadn't put up a single Christmas light, Halloween decoration, or anything remotely festive since New Year's Day. My name is Stephen Irving, and I'd been living in this cookie-cutter subdivision for 3 years, mostly keeping to myself and following every ridiculous rule they threw at homeowners. The grass stayed exactly 2.5 inches tall, my mailbox was regulation black, and my house was painted in one of the 7 approved neutral tones. I worked from home as a software developer, which meant I rarely left except for groceries and my monthly appointments at the medical marijuana dispensary, where I picked up my prescription. After a car accident 2 years ago left me with chronic back pain, I'd gotten my medical card and found that cannabis was the only thing that helped me function without turning into a zombie on prescription painkillers. The thing was, I'd recently decided to start growing my own plants. Arizona law allowed medical card holders to cultivate up to 12 plants if they lived more than 25 miles from a dispensary. And while I was technically closer than that, there was a provision for patients whose access to dispensaries was limited or who needed specific strains. My doctor had written me a recommendation for a particular high CBD strain that wasn't consistently available at local dispensaries, and with that letter, I'd gotten approved for home cultivation through the Arizona Department of Health Services. Everything was legal, documented, and by the book. The grow lights, though, that's what this was about. I'd converted my spare bedroom into a small grow room, installing proper ventilation, temperature controls, and yes, some very bright LED grow lights that ran on a specific schedule to simulate natural sunlight cycles. The lights were purple and pink, giving off that distinctive glow that anyone who knew anything about indoor gardening would recognize immediately. They were on a timer, running from 6 in the morning until 10 at night, and apparently someone had noticed the colorful glow coming through my window. I grabbed my phone and called the HOA office, reaching the property management company that handled Meadowbrook Estates. A bored-sounding receptionist transferred me 3 times before I got someone who claimed to know about my violation. "This is Patricia speaking. How may I assist you today?" The voice was saccharine sweet in that way that immediately set my teeth on edge. "Yeah, hi. I received a violation notice about holiday decorations, but I don't have any holiday decorations up. There's obviously been some kind of mistake. Let me pull up your file." I heard typing in the background. "You're at 4782 Saguaro Lane." "That's correct. According to the notice filed by our HOA president, you have excessive colored lighting visible from the street that appears to be Christmas or holiday related. The covenant clearly states that holiday decorations must be removed within 2 weeks of the holiday's conclusion. But they're not holiday lights. They're grow lights for my plants." "Sir, the type of light doesn't matter. The covenant addresses the visibility and appearance from the street. Colored lights displayed in windows are considered decorative and must comply with our guidelines." I felt my jaw tighten. "They're medical marijuana plants. I have a license from the state of Arizona to grow them. These are specialized horticultural lights, not decorations." There was a pause. "That's something you'll need to discuss with the HOA board. I'm just processing the violation that was filed." "Who filed it?" "Our HOA president, Donna Caldwell. She conducted a neighborhood inspection last week. Of course it was Donna. I'd met her exactly once, at a mandatory new homeowner orientation 3 years ago, and she'd struck me as the kind of person who measured her self-worth by how many people she could boss around. She was probably in her early 50s, with that particular haircut that seemed to be standard issue for women who asked to speak to managers. And she'd spent the entire orientation meeting talking about the importance of maintaining property values and neighborhood aesthetics. "I want to appeal this," I said. "You can submit a written appeal to the board. They meet on the first Tuesday of every month. That would be next week, actually." "Great. How do I submit it?" "Email it to the management company by Friday at 5 p.m. The address is on the letterhead." I hung up and immediately started drafting my appeal. I kept it professional, explaining that I was a licensed medical marijuana cultivator under Arizona state law, that the lights were necessary for the medical cultivation of plants prescribed by my doctor, and that removing them would interfere with my legal medical treatment. I attached copies of my medical marijuana card, my cultivation license, my doctor's recommendation, and the relevant sections of Arizona revised statutes that protected medical marijuana patients from discrimination. Friday came and went. The following Tuesday, I showed up at the community center where the HOA board held their monthly meetings. The room was set up with a long table at the front where 5 board members sat, and about 20 plastic chairs facing them for residents. Only 3 other homeowners were there, plus me, all of us clearly present to contest various violations or request approvals for modifications. Donna Caldwell sat in the center of the board table like a queen on her throne. She wore a cream-colored blazer and had reading glasses on a chain around her neck. To her right was an older man I didn't recognize, and to her left were 3 other middle-aged residents I'd seen around the neighborhood but never spoken to. "Let's begin with old business," Donna announced, not bothering with any pleasantries. She went through approvals for someone's fence modification, and a debate about whether another resident could paint their front door navy blue instead of the approved midnight blue, which apparently were different enough colors to matter. Finally, she got to my case. Appeal from Stephen Irving regarding violation notice me-25-047. Mr. Irving, you have 5 minutes to present your case. I stood up, my printed documents in hand. "Thank you." As I explained in my written appeal, the lights visible in my window aren't holiday decorations. They're horticultural grow lights for medical marijuana plants that I'm legally licensed to cultivate under Arizona state law. I've provided documentation showing my medical marijuana card, my cultivation license from the Arizona Department of Health Services, and my doctor's recommendation for home cultivation of specific strains for my chronic pain condition. Donna didn't even look at the papers. "Mr. Irving, this board is not concerned with what you're using the lights for. Our concern is the appearance of the neighborhood and maintaining property values. The colored lights are visible from the street and create an appearance that is not in keeping with our community standards. But they're not decorative. They're medical equipment, essentially." The older man next to Donna leaned forward. "Son, if you need to grow these plants, can't you do it in your garage or somewhere that isn't visible from outside? The spare bedroom has the proper electrical setup and ventilation. Converting another space would cost thousands of dollars and might not be safe or effective. Besides, I have the legal right to cultivate these plants. State law protects medical marijuana patients from discrimination." Donna held up a hand. "Mr. Irving, we're not discriminating against you. We're enforcing our covenants, conditions, and restrictions that you agreed to when you purchased your home. Those covenants predate the state's marijuana laws and make no exception for medical cultivation or any other use. The covenant section, 12.3, clearly states that no colored or decorative lighting may be visible from the street, except during approved holiday periods. The state law specifically says that HOAs cannot prohibit medical marijuana cultivation, I countered, pulling out the printed statute. Arizona Revised Statute 36-2814.02 states that a landlord or property owner cannot prohibit medical marijuana use or cultivation in a leased space, and case law has extended similar protections to homeowners in HOA communities. "We're not prohibiting your cultivation," Donna said with a tight smile. "We're regulating the visibility of the lights. You're free to grow your plants. You just need to ensure the lights aren't visible from outside your home. Block the windows, move the operation to an interior room, or find another solution. But the lights cannot remain visible as they currently are. That's effectively prohibiting cultivation. Those plants need specific light cycles to grow properly. Interior rooms don't have the ventilation I need. Blocking the windows would create heat and humidity problems." One of the other board members, a woman with short gray hair, spoke up. "What if you installed better curtains? Blackout curtains would prevent the light from showing through. The window provides passive ventilation and temperature regulation. Blocking it completely would require me to install additional equipment." "That sounds like your problem, not the HOA's," Donna said. "The violation stands. You have 30 days to come into compliance, or the fine will increase to $1,000, with additional daily fines of $50 until the violation is corrected." I felt heat rising in my face. This is discrimination against a medical patient. I have a legal right to grow these plants. "You have 30 days, Mr. Irving. Next item on the agenda." I wanted to argue more, but the other board members were already looking at their papers, moving on. The other residents in the room gave me sympathetic looks, but nobody said anything. This was how it worked in HOA land. The board had the power, and residents had to either comply or fight. I left the meeting furious and immediately started researching lawyers. The problem was, HOA law was complicated, and most attorneys wanted hefty retainers just to take the case. I spent the next week calling different law offices, explaining my situation, and getting quoted fees ranging from $5,000 to $15,000 just to start. For a $500 fine, it didn't make financial sense, but this was about the principle. They were interfering with my medical treatment. On day 10 of my 30-day compliance period, I got another letter. This one wasn't from the management company. It was from Donna Caldwell personally, on HOA letterhead, informing me that she would be conducting a property inspection the following Tuesday to verify compliance with the original violation notice and to check for any additional covenant violations that might need to be addressed. The letter had a threatening tone, like she was daring me to keep fighting her. I called my doctor, Dr. Sarah Martinez, who'd written my original medical marijuana recommendation. She agreed to write a detailed letter explaining why the grow lights were medically necessary and why alternative solutions wouldn't work for my specific situation. She also mentioned that sudden disruption of my treatment regimen could cause serious medical complications, including a return to prescription opioid use, which carried its own risks. Armed with her letter, I tried calling Donna directly. The management company gave me her number after I insisted it was urgent. She answered on the fourth ring. "This is Donna." "Mrs. Caldwell, this is Stephen Irving from Sagaro Lane. I wanted to discuss the violation notice and see if we could find a reasonable accommodation." "Mr. Irving, The board has made its decision. You have 20 days left to comply. I understand, but I wanted to explain that my doctor has written a letter stating that disrupting my cultivation would interfere with my medical treatment. This isn't just about preference, it's about managing a serious chronic pain condition. I'm sorry about your medical issues, Mr. Irving, but our responsibility is to all the homeowners in Meadowbrook Estates. Your situation doesn't give you the right to violate our covenants. The state law says otherwise. Arizona specifically protects medical marijuana patients from housing discrimination. And we're not discriminating. We're asking you to comply with reasonable aesthetic standards that apply to everyone equally. Other homeowners can't have colored lights visible year-round either. Other homeowners aren't using medical equipment. Then perhaps you should have considered that before purchasing a home in an HOA community. Her voice had gone cold. The inspection will proceed as scheduled next Tuesday at 10 a.m. Please be available to provide access to your property. You can't just inspect my property without my permission. According to Section 18.7 of the Covenant, the HOA has the right to inspect any property with 72 hours advance notice to ensure covenant compliance. I've given you more than 72 hours. See you Tuesday, Mr. Irving. She hung up before I could respond. The next few days were a blur of research and frustration. I learned that HOA law in Arizona was heavily weighted in favor of the associations, with homeowners having limited recourse unless they could prove the HOA was acting in bad faith or violating specific statutes. The medical marijuana angle was my best shot, but there wasn't much case law yet. Most disputes between HOA communities and medical marijuana patients had been settled out of court, which meant no precedent for me to cite. I also learned that Donna Caldwell had been HOA president for 8 years and had a reputation in the neighborhood for aggressive enforcement. I found online forum posts from other Meadowbrook residents complaining about her targeting specific homeowners, using inspections to harass people she didn't like, and allegedly fabricating violations. One former resident claimed she'd forced them to repaint their house 3 times because she kept claiming the color wasn't exactly the approved shade, even though they'd used the exact paint specified in the covenant. By Tuesday morning, I decided on a strategy. I wasn't going to give Donna access to my house. The covenant said they could inspect the property, but I interpreted that to mean the exterior, not the interior. The grow room was inside my home, and I had a reasonable expectation of privacy. Let her see what she could see from outside. At exactly 10 a.m., Donna's white Lexus pulled into my driveway. She got out wearing her typical blazer and khakis, carrying a clipboard and a digital camera. Behind her, a man in his 60s climbed out of the passenger seat. She'd brought backup. I met them at the front door before they could ring the bell. "Mr. Irving," Donna said with a strained smile. "This is Robert Fletcher, our HOA vice president. We're here to conduct the property inspection as notified." "You can inspect the exterior of the property from the public areas," I said calmly. "I'm not granting access to the interior of my home." Her smile disappeared. "The covenant grants us inspection rights. For the property, yes, not for the interior of my private residence. You can see the exterior, the front yard, and anything visible from the public right-of-way or common areas. That's the extent of your access. We need to verify compliance with the lighting violation. You can verify that from outside, can't you?" The violation was about lights visible from the street. Robert stepped forward, trying a diplomatic approach. "Mr. Irving, we're not trying to invade your privacy. We just need to document the current status for the board's records. It'll take 5 minutes." "No." You can document whatever you can see from outside my house, just like any other person could. If you need more than that, get a warrant." Donna's face flushed red. "We don't need a warrant, we have covenant rights." "Then take it up with a judge. I'm not letting you into my house." She stared at me for a long moment, and I could see her mentally calculating whether to push harder. Finally, she turned to Robert. "Let's document what we can see." They spent the next 20 minutes walking around my property, taking photos of my house from every angle. I watched from inside, tracking their movements through different windows. When they got to the side of the house where my spare bedroom was located, they spent extra time there, with Donna taking multiple photos of the window where the purple-pink glow of the grow lights was faintly visible even in daylight. After they left, I knew this was far from over. The next violation notice arrived 4 days later. This time, the fine had increased to $1,000 for failure to correct the original violation, plus 3 new violations. They claimed my lawn was 3 inches tall instead of the required 2.5 inches, that I had a small crack in my driveway that constituted poor maintenance, and that my front door mat was burgundy when only black, gray, or brown mats were permitted in the front entrance area. The total fines now added up to $2,000. It was harassment, pure and simple. I photographed my lawn with a ruler showing it was exactly 2.5 inches. The crack in my driveway was barely a hairline fracture that had been there since I moved in. And my door mat had been the same burgundy color for 3 years without any previous complaint. I documented everything and filed another appeal. This time, I also filed a complaint with the Arizona Department of Real Estate, which oversaw HOA management companies. I detailed the harassment, the medical discrimination, and the apparent bad faith enforcement of the covenants. It was a long shot, but I needed to start building a paper trail. I also finally bit the bullet and hired a lawyer. Her name was Rebecca Kowalski, and she specialized in HOA disputes and property rights. Her retainer was $3,000, which hurt, but she seemed confident that we had a good case. "The key is the Arizona Medical Marijuana Act protections," Rebecca explained during our first meeting at her office in downtown Phoenix. "The statute clearly states that registered qualifying patients can't be denied housing or subjected to discriminatory practices. The question is whether aesthetic covenants constitute a reasonable restriction or discriminatory interference with your medical treatment. What do you think?" "I think we have a strong argument that requiring you to eliminate or block the grow lights effectively prohibits your cultivation, which violates state law. But HOAs are tricky. They'll argue they're not prohibiting the activity, just regulating its visibility, and that their aesthetic standards apply equally to everyone. So what's our strategy? First, we send them a formal demand letter citing the medical marijuana protections and demanding they rescind all violations related to your cultivation activity. We give them 10 days to respond. If they don't, or if they respond with more threats, we file in Superior Court for injunctive relief and damages. How long does that take? Could be anywhere from 3 months to a year, depending on how aggressive they are in fighting it. But the good news is that once we file, any further enforcement actions by them start to look like retaliation, which strengthens our case. Rebecca drafted a detailed demand letter that laid out the legal framework and made it clear we were prepared to litigate. It went out via certified mail and email to both the management company and Donna Caldwell personally. The response came 6 days later, but not from a lawyer. It was another letter from Donna, this time informing me that the HOA board had voted to place a lien on my property for the unpaid fines, which now totaled $3,000 after additional daily penalties. If the fines weren't paid within 30 days, they would begin foreclosure proceedings. "They're escalating," Rebecca said when I forwarded her the letter. "This is actually good for us. It shows they're acting aggressively despite being put on notice of the legal issues. We're filing first thing Monday morning." True to her word, Rebecca filed a complaint in Maricopa County Superior Court that following Monday. The complaint sought injunctive relief prohibiting the HOA from enforcing any violations related to my medical marijuana cultivation, removal of the property lien, reimbursement of all fines paid, attorney's fees, and damages for harassment and discrimination. It was a comprehensive filing that cited multiple statutes and included declarations from me, my doctor, and even an expert in horticultural lighting who explained why indoor cultivation required specific visible spectrum lights. The court assigned us a hearing date 6 weeks out for the preliminary injunction. In the meantime, I was technically still under the threat of foreclosure, but Rebecca assured me that the act of filing would likely pause any aggressive collection efforts while the legal issues were pending. She was wrong about that. 2 weeks after we filed, I came home from a grocery run to find a notice taped to my front door. The HOA had filed for an emergency hearing in Justice Court to enforce the property lien, claiming that my continued violation posed an immediate threat to neighborhood property values, and that delay in enforcement would cause irreparable harm to the association and its members. "This is insane," I told Rebecca over the phone. "How can they claim emergency status? They're forum shopping," she said, sounding annoyed. "Justice Court is faster and less formal than Superior Court. They're hoping to get in front of a judge who doesn't understand the complexities of the medical marijuana law and get a quick ruling in their favor. Can they do that when we already have a case filed in Superior Court? It's questionable. We'll file a motion to consolidate and argue that Justice Court lacks jurisdiction since the Superior Court case addresses the same issues. But we need to appear at their hearing, or we risk a default judgment." The Justice Court hearing was set for the following Thursday at 2 p.m. Rebecca and I showed up to find Donna Caldwell, Robert Fletcher, and the HOA's attorney, a young guy named Marcus something who looked fresh out of law school. The courtroom was small and cramped, nothing like the imposing Superior Court buildings you see on TV. The judge, an older woman named Judge Patricia Hendricks, called our case first. Marcus stood up and launched into his argument. "Your Honor, this is a straightforward covenant enforcement matter. The defendant, Mr. Irving, has repeatedly violated the community's aesthetic standards by displaying colored lights that are visible from the street. Despite multiple notices and opportunities to comply, he has refused to correct the violation. The HOA has properly assessed fines according to its governing documents and now seeks to enforce those fines through the lien process as permitted under Arizona law." Judge Hendricks looked at Rebecca. "Counsel, Your Honor, this matter is not straightforward at all. Mr. Irving is a registered medical marijuana patient who is legally cultivating plants under state law. The lights in question are medical grow lights, not decorations. Arizona Revised Statute 36-2814.02 specifically protects medical marijuana patients from housing discrimination, and attempting to prohibit or interfere with legal cultivation violates that statute. We've already filed a comprehensive complaint in Superior Court addressing these exact issues, and this court should defer to that proceeding." Marcus jumped back in. "Your Honor, the HOA isn't prohibiting Mr. Irving's cultivation. We're simply requiring that he comply with aesthetic standards that apply to all residents equally. He can grow his plants. He just needs to ensure the lights aren't visible from outside his home, which effectively prohibits cultivation, Rebecca countered. The lights must be visible to function properly. Blocking windows would create safety and efficacy issues with the growing environment. This is a distinction without a difference, an attempt to circumvent state law through pretextual enforcement of aesthetic rules. Judge Hendricks looked thoughtful. Does the HOA have any evidence that these lights are actually harming property values or creating a genuine aesthetic problem? Marcus fumbled with his papers. Well, Your Honor, we have testimony from the HOA president that the lights are inconsistent with community standards and that other residents have complained. Do you have any actual complaints from other residents? In writing? Not in writing, Your Honor, but Mrs. Caldwell has received verbal complaints. The judge turned to Donna, who was sitting in the gallery. Mrs. Caldwell, how many residents have complained to you about Mr. Irving's lights? Donna stood up, smoothing her blazer. Your Honor, I've received multiple complaints from concerned neighbors who feel the lights are inappropriate and affect the neighborhood's appearance. How many is multiple? And do you have any documentation of these complaints? I didn't ask residents to put their complaints in writing, but I would estimate 5 or 6 people have mentioned it to me. Out of how many homes in the community? We have 247 homes in Meadowbrook Estates. Judge Hendricks made a note. So roughly 2% of residents, and none of them felt strongly enough to file a written complaint. Donna's face reddened. The number of complaints doesn't change the fact that there is a covenant violation. It speaks to the question of harm, the judge said. She looked back at Rebecca. Counsel, you mentioned a Superior Court case. What's the case number? Rebecca provided it, and the judge typed something into her computer. After a moment, she nodded. I'm going to stay this proceeding pending the outcome of the Superior Court case. That court is better positioned to address the constitutional and statutory questions raised by the medical marijuana issue. The lien will remain in place, but cannot be enforced until the Superior Court makes its ruling. Any objections? Marcus started to speak, but the judge held up her hand. That was rhetorical, counsel. My ruling stands. Next case. We walked out of the courthouse, and I felt like I just won a major victory, even though technically we just delayed things. That was good, Rebecca said. Judge Hendricks saw through their forum shopping. Now we focus on the Superior Court case and build the strongest possible record. Over the next month, discovery started in earnest. Rebecca sent interrogatories and document requests to the HOA, demanding copies of all communications related to my case, all other covenant enforcement actions taken in the past 5 years, minutes from board meetings, and documentation of any other residents who'd had similar issues. What came back was enlightening. In the past 5 years, the HOA had filed violations against 73 homeowners. Of those 73, 40 had been filed by Donna Caldwell personally during her neighborhood inspections. The violations ranged from the petty, like my doormat color, to the absurd, like one resident being cited because their lawn had clover mixed in with the grass. But what really caught Rebecca's attention was that nearly all of Donna's violations had been filed against homeowners who'd previously disagreed with her at board meetings or voted against her in HOA elections. This is a pattern of retaliatory enforcement, Rebecca explained, spreading the documents across her conference table. Look at this one. Margaret Chen voted against Donna in the last board election. 2 weeks later, she got 5 violations for things that had been on her property for years. Or this one, David Park spoke against Donna's proposal to increase HOA fees. A month later, 7 violations. So I'm not special, I'm just the latest target. Exactly. And this strengthens our case significantly. It's not about your lights or the covenants. It's about Donna using her position to harass and punish homeowners she doesn't like. That's abuse of power and potentially exceeds the HOA's authority under Arizona law. Rebecca also deposed Donna, and I got to watch the video later. Donna was defensive and evasive, insisting she was just doing her duty as HOA president, but unable to explain why her violation rate was 3 times higher than any other board members, or why so many of her targets were people who'd opposed her politically within the HOA. The most damaging moment came when Rebecca asked about other residents with visible indoor lighting. "Mrs. Caldwell, are you aware of any other homeowners in Meadowbrook Estates who have colored or bright lights visible from outside their homes?" "Not that I've noticed." "You haven't noticed the aquarium lights at 4823 Desert Willow Drive? That home has a large saltwater aquarium in their front living room window with blue LED lighting that's visible from the street at night." Donna shifted in her seat. "I may have seen that, yes." "Have you issued any violations to that homeowner?" "No." "Why not? Aquarium lights are different. They're not as bright or distracting." "Have you measured the brightness or conducted any objective comparison?" "No, but it's obvious that holiday-style lights are more intrusive than aquarium lights." "But Mr. Irving's lights aren't holiday lights. They're grow lights. And according to our expert's report, they're actually less bright than typical aquarium lights when measured in lumens." "So why did you target his lights specifically?" "Because they're for marijuana plants." There it was. Rebecca had gotten her to admit that the real issue wasn't the lights at all, it was what they were being used for. "So your objection is to the medical marijuana cultivation, not the aesthetic impact of the lights?" Donna's lawyer interrupted at that point, and they went off the record. But the damage was done. Our hearing for the preliminary injunction was scheduled for mid-May. The weekend before, I was working in my grow room, checking the plants and adjusting nutrient levels, when I heard voices outside. I looked out the window to see Donna and 2 men I didn't recognize standing in my side yard, taking photos of my window. I went outside immediately. "What are you doing on my property?" Donna turned, not even looking embarrassed. "Documenting ongoing violations for the court hearing." "You're trespassing. Get off my property right now." "The covenant gives us inspection rights from public areas and common spaces." "My side yard is not a common space. Leave now or I'm calling the police." One of the men with her held up a badge. "Sir, I'm Officer Dale Morrison with the Phoenix Police Department. We're conducting an investigation." My stomach dropped. "Investigation of what?" "We received a report of possible illegal drug cultivation at this address. We're here with Mrs. Caldwell to assess the situation." "I'm a licensed medical marijuana patient with legal cultivation authorization from the state. Everything I'm doing is completely legal." "Do you have documentation of that?" "Yes, inside. But you're still on my property without a warrant." "Mrs. Caldwell provided us with access through the HOA's inspection rights. She doesn't have the authority to grant you access to my private property." "The HOA covenant doesn't override the Fourth Amendment." The officer looked uncertain. The other man, also in police uniform, spoke up. "Sir, we're not trying to violate your rights, but if you're cultivating marijuana, we need to verify that it's legal." "Fine. Wait here. I'll get my documents." I went inside, my heart pounding, and grabbed my folder with all my medical marijuana paperwork. I brought it out and showed them my registration card, my cultivation license, and my doctor's letter. The officers looked it over, took photos of the documents with their phones, and nodded. "Everything appears to be in order," Officer Morrison said. "Sorry for the confusion." "The confusion was caused by her," I said, pointing at Donna. "She's been harassing me for weeks because she doesn't like that I'm growing medical marijuana. This is retaliation for my lawsuit against the HOA." "That's a civil matter," the officer said diplomatically. "We just needed to verify the cultivation was legal. Have a good day, sir." They left, with Donna shooting me a venomous look as she walked back to her car. I immediately called Rebecca and told her what happened. She was livid. "She called the police on you, trying to use law enforcement to harass you over a civil dispute, apparently. What can we do about it? It's another piece of evidence showing her intent to target you specifically. I'm going to amend our complaint to include this incident. And honestly, at this point, we should consider adding claims for intentional infliction of emotional distress and possibly abuse of process." The hearing finally came. Superior Court Judge Michael Reynolds presided, a distinguished-looking man in his 60s who'd been on the bench for 20 years according to Rebecca's research. The courtroom was much more formal than Justice Court, with high ceilings and dark wood paneling. Rebecca presented our case methodically, walking through the medical marijuana statute, the protections afforded to patients, and the evidence showing that the HOA's enforcement action effectively prohibited my legal cultivation. She introduced my testimony about the medical necessity of the grow lights, my doctor's declaration, and the expert opinion about horticultural lighting requirements. Then she pivoted to the discrimination and harassment evidence, showing the pattern of retaliatory enforcement, the disproportionate number of violations filed against homeowners who'd opposed Donna politically, and the recent incident where Donna had called the police. The HOA's attorney, they'd upgraded from Marcus to a more senior lawyer named Patricia Drummond, argued that the covenant enforcement was neutral and applied equally to all residents. She claimed that the medical marijuana statute didn't override private covenant agreements, and that the HOA had both the right and the duty to maintain community standards. Judge Reynolds asked pointed questions of both sides. He wanted to know specifically how blocking the windows would harm my cultivation efforts, so Rebecca called our expert witness, Dr. Thomas Chen, a horticultural specialist from the University of Arizona. Dr. Chen explained in detail how cannabis cultivation required specific light spectrums, temperatures, and humidity levels, and how the current setup in my spare bedroom was designed as an integrated system. Blocking the windows would trap heat and humidity, requiring expensive additional equipment to compensate, and even then, the success rate would be lower. Could the operation be moved to another location in the home? Judge Reynolds asked. Theoretically, Dr. Chen said, but it would require significant reconstruction. The spare bedroom was ideal because it had the electrical capacity, the window ventilation, and the space needed. Converting a garage or basement would cost thousands of dollars and might not be feasible depending on the specific layout. The judge then asked Donna to testify. She took the stand confidently, but that confidence eroded as Rebecca cross-examined her. "Mrs. Caldwell, you testified that you've received multiple complaints about Mr. Irving's lights. Can you name even one specific resident who complained?" "I don't remember their names off the top of my head." "You don't remember a single name, but you're certain multiple people complained." "Yes, people stopped me around the neighborhood and mentioned things. But you didn't document any of these complaints." "No." "Isn't it true that the HOA requires written complaints for covenant enforcement actions?" "Generally, yes, but board members can also initiate enforcement based on our own observations." And you initiated this enforcement action after observing Mr. Irving's lights during a neighborhood inspection. Correct. The same inspection where you filed violations against 5 other homeowners, 4 of whom had voted against you in the last board election. I don't remember how people voted. Really? Because the HOA election records show those votes were recorded, and your violation records show a pattern of targeting homeowners who opposed you. Patricia Drummond objected and the judge sustained it, but the point had been made. Rebecca then brought up the police incident. Mrs. Caldwell, did you call the Phoenix Police Department to report suspected illegal drug activity at Mr. Irving's home? I called to report a potential violation of drug laws, yes. Even though you knew Mr. Irving had a medical marijuana license, I wanted to make sure everything was actually legal. Had you ever called the police on any other homeowner for any reason? No. So Mr. Irving was the only homeowner you felt warranted police involvement. It was a unique situation. Unique because he was suing the HOA, unique because of the marijuana. Medical marijuana, which is legal in Arizona. I'm aware of that now. The hearing lasted 4 hours. At the end, Judge Reynolds said he would take the matter under advisement and issue a written ruling within 2 weeks. Those 2 weeks felt like 2 years. I kept checking the court's electronic filing system obsessively, waiting for the ruling to appear. Rebecca told me to relax, that these things took time, but I couldn't help it. My financial situation was getting tight between the legal fees and the constant stress, and I just wanted resolution. The ruling came 13 days after the hearing. It was 23 pages long, and I read it 3 times to make sure I understood everything. Judge Reynolds ruled in my favor on every major point. He found that the Arizona Medical Marijuana Act's anti-discrimination provisions applied to HOA covenant enforcement, that requiring me to eliminate or block the grow lights constituted effective prohibition of legal cultivation, and that the HOA's enforcement action violated state law. He issued a permanent injunction prohibiting the HOA from enforcing any violations related to my medical marijuana cultivation lights, ordered the removal of the property lien, and awarded me damages of $5,000 for the harassment and illegal lien. He also awarded attorney's fees, which meant the HOA would have to reimburse Rebecca's costs. That was huge, because my legal bills had climbed to nearly $8,000 at that point. But the best part was the finding regarding Donna's conduct. Judge Reynolds specifically noted the pattern of retaliatory enforcement, called it troubling and inconsistent with the fiduciary duties of an HOA board member, and suggested that the HOA members might want to consider whether their current leadership was serving the community's best interests. I called Rebecca as soon as I finished reading. We won. We actually won. I told you we had a good case, she said, and I could hear the smile in her voice. But yes, this is a complete victory. Judge Reynolds didn't just rule in your favor, he demolished their arguments. What happens now? The HOA has 30 days to appeal if they want to, but I doubt they will. This ruling is solid, and an appeal would just cost them more money for a case they are unlikely to win. They'll probably vote to accept the judgment and move on. And the damages? They have to pay within 60 days unless they appeal, plus our attorney's fees. I'll submit a detailed fee petition to the court. I felt a weight lift off my shoulders that had been there for months. I could keep my grow lights, keep my plants, and nobody could harass me about it anymore. The story should have ended there, but Donna Caldwell wasn't done. 3 weeks after the judgment, I got a call from Robert Fletcher, the HOA vice president. He asked if he could come by to talk, and something in his voice made me agree. He showed up that evening looking uncomfortable. Mr. Irving, I wanted to apologize for how this whole situation was handled. I should have pushed back harder against Donna's enforcement approach. Okay, I appreciate that. The board held a meeting last night. Several of us have been concerned about Donna's leadership for a while, but this lawsuit was the final straw. We've voted to remove her as president, and we're considering asking for her resignation from the board entirely. That's your decision to make. The thing is, we've been reviewing the HOA's finances in light of the judgment we have to pay, and we found some irregularities. It looks like Donna may have been misusing HOA funds. That got my attention. How so? She's been paying herself a monthly stipend that was never approved by the board. She claimed it was for administrative expenses, but it's not in our budget, and there's no documentation for what the money was used for. We're talking about almost $2,000 a month for the past 3 years. That's over $70,000. Exactly. We've contacted a forensic accountant to do a full audit. I wanted to give you a heads up, because if we find evidence of embezzlement or fraud, we'll have to report it to the authorities. Given your lawsuit, you might end up being contacted as part of any investigation. I thanked him for the information and called Rebecca after he left. She was very interested. If she's been embezzling HOA funds, that's criminal, not civil. The HOA could file a police report, and if charges are filed, it would vindicate your position even more. Everyone would see that she was corrupt and targeting you for personal reasons. Should I do anything? Just cooperate if the police contact you. Otherwise, let the HOA handle their internal issues. The forensic audit took 6 weeks. During that time, I kept growing my plants, worked my job, and tried to return to normal life. The grow lights glowed purple-pink in my window every day, and nobody said a word about them. In late July, Robert called again. We've completed the audit. It's worse than we thought. Donna took over $90,000 from HOA funds over 4 years. She was using a complicated scheme of fake vendor invoices for landscaping and maintenance that never actually happened. The board voted unanimously to file a police report and to pursue civil recovery. Wow, I knew she was vindictive, but I didn't think she was a thief. Neither did we. The police are opening a criminal investigation. They'll probably want to interview everyone who had conflicts with her, including you. The detective who contacted me was a woman named Detective Sarah Williams from the Phoenix Police Department's White Collar Crimes Unit. She came to my house, asked detailed questions about my interactions with Donna, and seemed particularly interested in the timeline of her harassment campaign against me. It fits the pattern, Detective Williams explained. She targeted homeowners who questioned her authority or might have noticed financial irregularities. You weren't on the board, but you were fighting back legally, and that made you a threat. The harassment was partly personal vindictiveness, and partly an attempt to intimidate someone who might cause problems for her. Did she steal from other homeowners directly? Not directly, but she stole from the HOA, which means she stole from every homeowner's equity in the community. Those funds should have gone to maintenance, reserves, and improvements. Instead, they went into her pocket. The criminal case moved forward through the summer and fall. Donna was arrested in August and charged with theft, fraud, and misuse of fiduciary property. The local news covered it, running stories about the HOA president who'd embezzled nearly $100,000 while harassing residents over minor covenant violations. One news crew actually came to my house, asking if I would comment. I declined to appear on camera, but I gave them a statement through Rebecca explaining that I'd been targeted by Donna for growing legal medical marijuana, and that the court had ruled in my favor. The story ran with the headline, HOA President Charged with Embezzlement After Losing Medical Marijuana Lawsuit. Donna's trial was scheduled for January of the following year. She initially pleaded not guilty, but as the evidence mounted and more homeowners came forward with stories of her retaliatory enforcement and financial mismanagement, her attorney negotiated a plea deal. In December, she pleaded guilty to theft and fraud charges. The judge sentenced her to 3 years in prison, with eligibility for early release after 18 months with good behavior, and ordered her to pay full restitution to the HOA. She also had to surrender her real estate license and was permanently banned from serving on any HOA board in Arizona. I attended the sentencing hearing. I wanted to see the end of the story, to watch the woman who'd made my life hell for months face consequences for her actions. Donna looked smaller somehow, her usual confidence gone, replaced by a resigned sadness. When the judge asked if she had anything to say before sentencing, she gave a brief statement apologizing to the homeowners of Meadowbrook Estates and acknowledging that she'd abused her position. She didn't mention me specifically, but our eyes met briefly as she was led out of the courtroom in handcuffs. I didn't feel triumphant or vindicated. I just felt tired and relieved that it was finally over. The HOA elected new board members in February, including several younger residents who'd been frustrated with the old guard's heavy-handed enforcement style. One of their first acts was to revise the covenant enforcement procedures, requiring written complaints from multiple residents before violations could be filed, and creating an independent appeals committee to review disputes. They also formally apologized to me in a letter from the new board president, acknowledging that I'd been unfairly targeted and thanking me for standing up for homeowner rights. It was a nice gesture, though frankly I would have preferred to never have gone through the whole ordeal in the first place. My plants grew beautifully under the purple-pink glow of my grow lights. I harvested my first batch in March, exactly 1 year after receiving that initial violation notice, and the high CBD strain my doctor had recommended worked better than anything I'd gotten from a dispensary. My chronic pain was manageable. I'd avoided going back on prescription opioids, and I could live my life without constant discomfort. The lawsuit settlement money came through in April, along with the attorney fee reimbursement. After paying Rebecca's final bills, I still cleared about $4,000. I used part of it to upgrade my grow room equipment, adding better ventilation and temperature controls. The rest went into savings, a cushion in case I ever had to fight for my rights again. Word spread through the neighborhood about what had happened. Other homeowners started approaching me at the mailbox or when I was outside, thanking me for standing up to Donna and making the HOA more accountable. A few of them shared their own stories of harassment and unfair violations. One older woman, Helen, told me Donna had fined her repeatedly for having a bird feeder in her yard, claiming it attracted pests, even though multiple other homes had bird feeders without any issues. She just didn't like me because I voted against her fee increase, Helen said. But I was too scared to fight back. Legal fees are expensive when you're on a fixed income. You should file a claim for restitution as part of Donna's criminal case, I suggested. The court ordered her to pay back what she stole. Maybe that includes refunding unfair fines. Helen took my advice, and so did several other homeowners. The restitution fund eventually totaled over $130,000 when all the financial damage was calculated. Donna would be making payments for years. Life settled into a comfortable rhythm. I worked from home, tended my plants, and enjoyed the peace of not having to worry about HOA violations every time I checked my mail. The new board proved to be reasonable and focused on actual community issues like road maintenance and common area landscaping, rather than petty enforcement of aesthetic rules. In June, Arizona expanded its medical marijuana laws to allow for recreational use, which made my situation even less controversial. Suddenly, home cultivation wasn't just for medical patients anymore. Any adult could grow up to 6 plants, or 12 if there were 2 adults in the household. The HOA couldn't have stopped it even if they wanted to, because state law now explicitly prohibited HOAs from banning legal cultivation. Rebecca called me when the new law passed. "You were ahead of the curve," she said. "If you'd waited another year, this whole fight wouldn't have been necessary." Or maybe my fight helped pave the way, I suggested. If HOAs could see they couldn't bully medical patients, maybe that influenced the legislative debate about recreational legalization. Could be. Either way, you should be proud. You stood up for your rights when it would have been easier to just give in. I was proud, actually. Not because I'd won or because Donna had gone to prison, but because I'd proven that even in an HOA community with all its rules and restrictions, homeowners still had fundamental rights that couldn't be violated. Medical treatment, privacy, and legal activities conducted in your own home were protected, regardless of what some power-hungry board president thought about aesthetics. My grow room became something of a model for other residents interested in cultivation. After recreational legalization passed, 3 of my neighbors asked if they could see my setup and get advice on starting their own grows. I happily showed them around, explaining the lighting requirements, nutrient schedules, and environmental controls. 2 of them ended up installing their own grow rooms, and neither received any complaints from the HOA. The purple-pink glow of grow lights became a common sight in Meadowbrook Estates by the end of the year. What had started as a source of conflict and harassment became normalized, just another feature of modern suburban life. Some people had aquariums, some had elaborate computer gaming setups, some had home gyms, and some grew their own cannabis. It was all just different ways people used their private property. I occasionally wondered what Donna thought about that, sitting in her prison cell. Did she regret targeting me so aggressively? Did she understand that her obsessive need for control had ultimately destroyed her life? Or did she still believe she'd been right, that maintaining rigid aesthetic standards was worth any cost? I'd never know, and honestly, I didn't care. She was no longer part of my life, no longer part of the HOA, and no longer in a position to hurt anyone. That was enough. The final chapter of the story came in September, when I received a check in the mail from the State Restitution Fund. It was for $875, representing a partial reimbursement for the legal fees and stress damages from my lawsuit. Donna's court-ordered restitution payments were being distributed to her victims in proportion to their losses. I deposited the check, added it to my savings, and treated myself to dinner at a nice restaurant in downtown Phoenix. Sitting on the patio, eating excellent food and watching the sunset paint the sky in shades of orange and purple, I reflected on everything that had happened. A year and a half ago, I'd received a violation notice for holiday lights in March, not understanding that it would lead to months of legal battles, a corruption investigation, and fundamental changes in how my HOA operated. If someone had told me then how it would all turn out, I wouldn't have believed them. Life was strange that way, full of unexpected twists and consequences, but I'd learned important lessons. I'd learned that standing up for your rights mattered, even when it was expensive and stressful. I'd learned that bullies often have something to hide, and that shining light on their behavior can reveal deeper corruption. And I'd learned that communities are made up of individuals, and when individuals stand up for principles, the whole community can change for the better. My purple-pink grow lights still glowed in my spare bedroom window every evening, visible from the street to anyone who cared to look. They weren't holiday decorations. They weren't covenant violations. They were a symbol of personal freedom, medical rights, and the simple principle that your home should be your castle, free from arbitrary harassment by petty tyrants. And if someone didn't like the colored glow in my window, well, they were welcome to mind their own business. Because in the end, that's what being part of a community should really mean, respecting each other's rights and choices, not enforcing conformity through fear and intimidation. The plants grew strong and healthy under those lights, producing medicine that improved my quality of life. That was what mattered. That was what the whole fight had been about. And as I sat in that restaurant, watching the Arizona sunset and feeling the chronic pain in my back reduced to a manageable background ache, I knew every dollar spent on legal fees, every stressful hearing, and every sleepless night worrying about foreclosure had been worth it. I'd won more than a lawsuit. I'd won the right to live my life in peace, to treat my medical condition legally and effectively, and to not be controlled by someone who thought their personal preferences should override state law and common decency. That was a victory worth celebrating, and a story worth telling to anyone facing similar battles against overreaching HOA boards. The system wasn't perfect. Legal fights were expensive and stressful, and not everyone had the resources or energy to stand up to institutional power. But the system could work when you built a strong case, found the right attorney, and refused to be intimidated. Judge Reynolds had seen through Donna's pretextual enforcement and recognized discrimination when it was presented to him. The criminal justice system had held Donna accountable for her theft and abuse of power, and the HOA community had ultimately chosen better leadership that respected homeowner rights. Sometimes justice took time, cost money, and required patience, but it was possible. And knowing that made all the difference. I finished my dinner, paid the check with some of that restitution money, and drove home through the Phoenix evening. My house sat quiet and welcoming on Saguaro Lane, the purple-pink glow of the grow lights visible in the window like a beacon. I pulled into my driveway, walked to my front door past my burgundy doormat that was still burgundy after all this time, and went inside to check on my plants. They were thriving, reaching toward the light, growing strong and healthy in their carefully maintained environment. I adjusted the temperature, checked the humidity levels, and made notes in my cultivation journal about their progress. This was my home, my sanctuary, my right to live as I chose within the bounds of the law. And nobody, not Donna Caldwell, not the HOA board, not anyone, could take that away from me ever again. The grow lights would continue glowing in my window for years to come. A quiet but persistent reminder that individual rights matter, that laws protecting medical patients have teeth, and that even the most powerful-seeming neighborhood tyrant is not above accountability. My story had a happy ending, but more importantly, it had helped create a better community for everyone in Meadowbrook Estates. That was the real victory, the lasting impact that went beyond my personal situation. Other homeowners knew they had rights now. They knew they could push back against unfair enforcement. They knew that documentation and legal protections existed if they needed them. And they knew that standing up to bullies, while difficult, could result in real change. My chronic pain condition would never go away completely, but with my medical cannabis and my home cultivation setup, I could manage it effectively and maintain a good quality of life. That was all I'd ever wanted, the simple right to treat my medical condition in the way that worked best for me, using medication that was legal under state law and prescribed by my doctor. It had taken a lawsuit, a criminal investigation, and a complete change in HOA leadership to secure that right, but it was secured now. And as I turned off the lights in the rest of the house and headed to bed, leaving only the purple-pink glow of the grow room illuminating the night, I felt grateful for that hard-won peace. Tomorrow would bring new challenges, as every day does. But the fight over my grow lights was finished, resolved in a way that protected not just me but other homeowners in similar situations across Arizona. The legal precedent from Judge Reynolds' ruling could be cited in future cases. The story of Donna's corruption would serve as a cautionary tale about the dangers of unchecked HOA power, and my purple-pink lights would keep glowing, growing medicine, and reminding everyone who saw them that freedom matters. That was enough. That was everything. And as I drifted off to sleep that night in my home on Saguaro Lane in Phoenix, Arizona, I knew that despite all the stress and struggle, I'd done the right thing by fighting back. Some battles are worth fighting, even when the odds seem stacked against you, because the principles at stake matter more than the cost or convenience. My medical marijuana plants would harvest again in a few months, providing medicine for my chronic pain. The HOA would continue operating under new, fairer leadership. Donna would serve her time and hopefully learn from her mistakes, and I would keep living my life, tending my garden, doing my work, and enjoying the simple peace of a home where I could make my own choices without harassment. The colored lights visible from my window weren't a covenant violation. They were a symbol of victory, perseverance, and the fundamental American principle that your home is your castle, and no petty tyrant can take that away without facing consequences. That was my story, my battle, and my hard-won peace. And it all started with a violation notice for holiday lights in March when I was just trying to grow medicine for my chronic pain. Funny how life works sometimes, turning a simple misunderstanding into a months-long legal battle that exposed corruption, changed community leadership, and established important precedents for homeowner rights. But that's exactly what happened, and I wouldn't change any of it, because the outcome was worth every difficult moment along the way. The grow lights glowed on into the night, nurturing life, producing medicine, and standing as a permanent testament to the importance of standing up for what's right, no matter how powerful the opposition might seem. That was my legacy in Meadowbrook Estates, the story people would tell about the homeowner who fought back against HOA overreach and won. And every time someone saw those purple-pink lights in my window, they'd remember that victory was possible, that rights could be defended, and that even in an HOA community, individual freedom still mattered. That thought carried me into peaceful sleep, my plants growing quietly in the next room, my home secure and protected by law, and my future bright with the knowledge that I'd stood up for myself and made a difference. The end of one chapter, perhaps, but really just the beginning of a better way of living in a community that had learned important lessons about power, accountability, and respect for individual rights. The lights would keep glowing, the plants would keep growing, and life would keep moving forward, better and freer than before.